I mean, this is a
Absolutely.
part of our system. This is a part of our system. If you're trying to put someone in a cage, you have to go testify against them. But the
But this is also a
so
significant burden, as we've all seen in every mafia movie. That if you go testify, then they're going to go put the muscle on you, and maybe your family gets hurt, and you wouldn't want your family to get hurt, would you? So then you don't go testify.
that's correct. But the amendment would say that constitutional right may be limited by law for certain witnesses, those under 18 and those with mental illness, including intellectual disability or other developmental disability. Both legislative chambers would need to approve this measure again in 2027 and again in 2028 to put it before the voters in November 2028. So it has a lot of hoops to jump through. You people in Iowa, if you don't like what you're seeing here, you better get to work because this is going to become a part of your Constitution very soon in the next 3 years.
The Sixth Amendment of the U.S. Constitution lays out the right of the accused in criminal prosecutions, specifying the right to a speedy trial, an impartial jury, and, among other things, to be confronted with the witnesses against him. Them. I pick them, Larry.
Well, except that's what it said. That's the way they wrote it in 1857 or wherever it was.
Like, women
Uh,
didn't even have the right to think back then.
so the Iowa Constitution was adopted in 1857, also defines the rights of persons accused, including the same confrontation clause. But the U.S. Supreme Court held in a 1990 decision, Maryland v. Craig, which I didn't know anything about this, that the right to confront accusatory witnesses may be satisfied absent a physical face-to-face confrontation when remote testimony is necessary and can be provided reliably. And that's what we've heard Scalia criticized. Maryland's interest in protecting child witnesses from trauma of testifying in a child abuse case is sufficiently important to justify the use of special procedures, that decision said. And the majority of courts across the country have aligned with the Supreme Court decision, according to Colin Miller, a University of South Carolina law professor.
The most common exception is when the state's confrontation clause includes the words face to face. That explicit text led the New Hampshire Supreme Court this year, for example, to say a 9-year-old girl's remote testimony violated the defendant's constitutional rights.